Mr. Salesh Kumar.
कंसाइंड में कहता है रजिस्ट्री की डिस्पोजल नहीं हुआ, कंसाइंड डिस्पोज्ड ऑफ. यस,
May please, my lord. My lord, this appeal, my lord, I have very limited, my lord, scope here before my lord, my lord.
Very
But,
limited
my
scope.
lord will, very limited scope, my lord, I am conscious of the fact. My lord, will kindly look into the order dated 24/1/19, my lord. In fact, my lord, I'll just give the background, my lord. The certain land acquisition proceeding was supposed to be initiated, which was not initiated, and my land was taken, my lord. I came before this honorable court, and if my lord has the record of the case, my lord, that would really felicitate my lord in understanding, my lord. It's
give
just
us
few
1
lines.
minute.
Ji.
MS Nirvikar, please give us
Ji.
1.
Ji. So last paragraph देख लिया जाए.
Just 1 minute.
जी.
Yes.
But let's, the land acquisition proceeding ought to have been initiated while taking my land, my lord, acquiring my land, my lord. That was not initiated. I came before this honorable court, my lord, and I was directed that two things should be considered by the other side, my lord, and dispose of my application. That was the nature of the land and the measurement of the land, my lord. These were the two issues. I agreed to the proposition that yes, my land may be taken, but since they should have proceeded anyways, my lord. Annexure 1 of the writ application was considered, and this is kind of observation which was granted to the respondents, my lord, and I was directed to appear before the appropriate authority. Now, pursuant to the direction of this honorable court, my lord, a measurement had also taken place. That is Annexure 2 of the writ application, my lord, page 14.
Minor difference.
My lords.
Minor difference in the two measurements.
No, my lords, not minor.
That's the observation of the
वो
court.
बाद में आया. मेरा जो सारा dispute है, it is because of this. Or pursuant to the direction of this court, my lord, the measurement took place, and in measurement the entire Rakwa was for 75 decimal, which has been, my lord, acquired by the respondents for the purposes of.
And you have been compensated for what area?
And now they have compensated me around 33, 34 decimal and 50%. 39 and 50% is gone, my lord.
All right, Mr. Pandey, what do you have to say about the observation made by the judge in the first instance, not here, with respect to, I'm talking to you.
My lord.
Why are you looking at the back? You're Pandey, you're Mr. No, Mr. Ambassador, I'm so sorry. I'm so sorry. In my quest to name every advocate, I at times commit mistake. So Mr. Manoj Ambastha, the first time that the appellant came before this court, it was found by the judge, not in the writ petition but in the contempt petition, that there is a minor difference between the land which was acquired and which was shown to have been acquired. Now therefore, with respect to computation of the compensation, the appellant was directed to go before the authorities. Instead of going there, the appellant, the landowner, comes to the High Court, and the single judge does not take into account the original part of the dispute, namely the difference in the measurement and the land acquired. Now forget about section 64, the forum where quantum of compensation could be determined. Now how about the area difference?
No, my lords,
if you are ready with the facts and if you have the points up your sleeve, all right, otherwise tell us after checking up the facts.
एक document बस दिखाना है. Writ stage में this case was being handled by late Shri Chittaranjan Prasad. ये LPA अभी 4 दिन पहले हमको अलॉट हुआ है,
ये
बट
तो-
नंदलेस
ये तो कोई जवाब नहीं हुआ ना। तो आपको पहले ही कहा कि अगर आप 4 दिन में नहीं
हम एक
किया-
चीज दिखा दे रहे हैं, उसके बाद जरूरत समझ देयर सब्सिक्वेंट कॉन्डक्ट आफ्टर द MJC ऑर्डर, हमने रिट में
नहीं,
ये
we are not looking into all that. I have put you a different.
they have executed a lease deed.
Try and understand. Now say yes or no. MS Nirvikar says that you show that you have shown in your record that 39 decimals of land was acquired for which you have paid her. You have paid her a paltry amount. The dispute with respect to compensation is different. Now she is not on that. She says that you have acquired 75
As
decimals
per
of
their
land.
own record.
I am disputing it in view of the
देखकर बताकर बताइए, because this matter has not been looked into by the learned single judge. The learned single judge only refers to the quantum and he says that you better go before the authorities under section 64.
माय लॉर्ड रजिस्टर्ड लीज डीड जो इन लोग के द्वारा सरकार से हुआ है, उसमें जो एरिया दिया है उसमें कोई डिस्प्यूट नहीं है, और एक लाइन वो लीज डीड का बस हम पढ़ दे रहे
नहीं,
हैं। आफ्टर दैट
लीज डीड
यह कि लेखे कारणीगण अपने खुशी राजी
वकील
लाभ
साहब, जब
हानि
बात नहीं समझेंगे तो आप इस तरह से
My lord.
दिखाने लगेंगे ना मिस्टर अम्बस्टा। बहस यही है कि आपने दिखाया 39, लीज डीड वही है, और जब कंज्यूम करने लगे आप एक्सकेवेशन में, तो आपने इनकी ज्यादा जमीन ले ली जिसके बारे में रिपोर्ट करना था। सिंगल जज ने उस बात को नहीं देखा और केवल क्वांटम पर चले गए कि कमर्शियल लैंड है कि नहीं है। नहीं समझा आप बस।
आई अंडरस्टूड।
पूरा बैकग्राउंड बताएंगे तो आपको अपने पढ़ के आना होगा ना। हाई कोर्ट इस बेंच को कहेंगे कि आपको समझाएं कि रिट पिटीशन क्या थी और अपील क्या है।
इसको 4
जो
सप्ताह
आपने
बाद
लीज डीड दिखाया है, ये self evident है that you have not understood the argument in the perspective in which it is being
No, no.
argued. Now lease deed is with respect to the land which you claim to have acquired, right? Later you were found to have acquired more land than what you show to have taken from the landowner. Where is the issue decided by the learned single judge on that aspect of the matter? How does the single judge say that the measurement was only of a width difference? WHIT, width
No.
difference. Now, how do you account for all this? Say that these questions of fact cannot be decided here in appeal. Or you say that the facts raised by MS Nirvikar is not correct. कुछ तो कहेंगे।
even otherwise my lord without looking into the writ because I
No,
don't have the copy।
Don't be so presumptive. Without looking into the petition,
हम
you will
नहीं,
make an argument.
हम कह रहे हैं कि 226 में या LPM में ये डिस्प्यूट कि कितना एरिया लगा है, या नेचर ऑफ लैंड विच कीप्स चेंजिंग विद
नहीं, ये
पैसेज
बहस
ऑफ
ठीक
टाइम।
है। ये बहस सिंगल जज ने भी किया है। अभी आप ये बताएं कि ये स्टेटमेंट कहां से आ गया कि दोनों जो कंज्यूम किया वो रिपोर्ट दिखाएं आप। वो जो रिपोर्ट सेकंड टाइम आया वो कहां है?
Lord, it will come up after 4 weeks because writ की copy is not available. I'll have to obtain a certified
नहीं,
copy।
हम इनको
इस
copy
बेटा।
दे देते हैं।
या
ये
copy दे
हम
देते
कॉपी दे
MS
देते हैं।
Nivedita Nirvikar, senior advocate, is requested to hand over a copy of the brief, including the records of the connected writ petition,
जी।
to Mr. Manoj Ambastal and Counsel for the State for him to respond appropriately on the next occasion. Re-notify on, give a date after 4 weeks.
3rd of August।
Let's-
You are on a very slippery ground, MS Nirvikar. All said and done, these facts cannot be decided here. But
नहीं नहीं, हम दूसरा इशू पे आ रहे
आप क्या
थे।
दूसरा
My lord, हम I was saying that there were 2 issues which were required to be decided when I came on the first occasion. That was the nature of land
That's
and
all
the
right.
amount.
Proceed
तो
further.
हम उसको छोड़ भी रहे हैं, हमको कोई issue
अब
नहीं
क्या
है।
चाहिए आपको?
Because what I was saying that my friend is requesting for 4 weeks time. Let him get 4 weeks time. But in between, my lord, I was just requesting कि हुजूर एक बार उसका measurement सिर्फ करवा लिया जाए। Why I was saying this?
no.
Why I was saying
We
this?
can't
नहीं,
direct
why I
for-
was saying this? Why I was saying this? My lord will appreciate I will not make any such submission which is not justified, my lord, at the present. What I was saying.
That's a very big statement.
No, my lord, I will not say anything because I have already informed my friend that so far as the nature of land is concerned, that cannot be decided by this honorable court. But now that the measurement has taken place twice.
We have some limitations in accepting.
No, हम सिर्फ इतना हम खत्म कर दे रहे हैं बात
सुनिए,
कहकर।
आप
हुजूर,
कह रही हैं
दो बार
दोबारा
इन्होंने
measurement
मेजरमेंट
करना।
कराया।
No, we are not directing for it.
नहीं, इन्होंने 2 बार मेजरमेंट कराया। एक बार इन्होंने कहा 75 डेसिमल, एक बार कहते हैं कि 35 डेसिमल।
हमने सुन लिया आपकी बात।
जी,
कोर्ट
तो
की
एक बार हुजूर सिर्फ मेजरमेंट, इस बीच में any independent person to just measure and that is over. We'll go back for the so far as the land is concerned, the nature of land is concerned.
कोर्ट का लिमिटेशन सुनेंगे आप?
जी,
कोर्ट का लिमिटेशन ये है
जी,
कि sitting in appeal we would not relegate ourselves to the position of a single judge to order for a fresh measurement. We shall not do that. It would amount to giving of it will tantamount to injecting life into something which has already been decided. So let us see, just a minute, let us see what is the report. Now we are not directing for a fresh report unless we are satisfied or dissatisfied about any second report. Therefore let him come up with the proposal. In the interregnum you sit tight and wait for the matter to be argued.
4 weeks will be too long a period. I am handing over the entire petition to him, my lords. He will just have to seek
He is
instruction.
not as quick as you.
नहीं तो 4 सप्ताह।
Like re-notify on so date.
2 weeks के बाद हम इनको
Mr. Why don't you object to this statement from the bench that you are not as quick in response as MS Nirvikar? You should say that let this matter be listed after 3 weeks only, not 4 weeks.
और केसेस भी हजूर के यहाँ लगा है तो
3 वीक कर दीजिए. Why should we give no confidence
प्राइवेट
in
वकील
Mr.
लोग के पास एक आध केस रहता है, सरकार में बहुत केसेस रहता है. That is very
27th of July.
true.
Yes.